Section 4. Resolution of Investigating Prosecutor and its review. If the investigating prosecutor finds the cause to hold the respondent for trial, he shall prepare the resolution and information. He shall certify under oath in the information that he, or as shown by the record, an authorized officer has personally examined the complainant and his witnesses, that there is reasonable ground to believe that a crime has been committed and that the accused is probably guilty thereof, that the accused was informed on the of the complaint and of the evidence submitted against him, and that he was given an opportunity to submit controverting evidence. Otherwise, he shall recommend the dismissal of the complaint. Within 5 days from his resolution, he shall forward the record of the case to the provincial or city prosecutor of the chief of state prosecutor, or to the ombudsman or his deputy in cases of offenses recognizable by the Sandigang Bayan in the exercise of his original jurisdiction. They shall act on the resolution with 10 days from the receipt thereof, and shall immediately inform the parties of such action. No complaint or information may be filed or dismissed by an investigation prosecutor without the prior written authority or approval of the provincial or city prosecutor or chief state prosecutor or the ombudsman of or his deputy. Where the investigating prosecutor recommends the dismissal of complaint but his recommendation is disapproved by the provincial or city prosecutor or chief of state prosecutor or the ombudsman or his deputy, on the ground that probable cause exists, the latter may by himself file the information against respondent or direct another assistant prosecutor or state prosecutor to do so without conducting another preliminary investigation. If upon petition by a proper party under such rules as the Department of Justice may prescribe or motu proprio, the Secretary of Justice reverses or modifies the resolution of the provincial or city prosecutor or chief of state prosecutor, he shall direct the prosecutor concerned either file the corresponding information without conducting another preliminary investigation, or to dismiss or move a dismissal of the complaint or information which notice to the parties. The same rule shall apply in preliminary investigation conducted by the officers of Office of the Ombudsman. Section 5. Resolution of Investigation Judge and his review. With 10 days after the preliminary investigation, the investigating judge shall transmit the resolution of the case to the provincial or city prosecutor or the ombudsman or his deputy in cases of offense cognizable by the Sandigan Bayan in the exercise of original jurisdiction for appropriate action. The resolution shall state the findings of facts and the law supporting his action. together with the record of the case, which shall include: letter A, the warrant, if the arrest of virtue of warrant of a warrant. B, affidavits, counter affidavits, and other supporting evidence of the parties. C, the undertaking bail of the accused and the order for his release. D, the transcript of the proceeding during preliminary investigation. And E, the order of cancellation of his bail bond if the resolution for this dismissal of the complainant within 30 days from receipt of the records, the provincial or city prosecutor or the ombudsman or his deputy, as the case may be, shall review the resolution of the investigating judge on the existing of probable cause. The ruling shall expressly and clearly state the facts and the law on which it is based, and the parties of furnish will copies thereof. They shall order the release or unaccused who is determined if no probable cause is found against him. Section 6. When warrant of arrest may issue: A, by the regional trial court within 10 days from the filing of the complainant or information, the judge shall personally evaluate the resolution of the prosecutor and its supporting evidence. He may immediately dismiss the case of his evidence on record clearly fails to establish probable cause. If he finds probable cause, he shall issue a warrant of arrest or commitment order. If the accused warrant issued by the judge who conducted preliminary investigation on when the complaint or information was filed pursuant in Section 7 of this rule. In case of doubt on the existence of probable cause, the judge may order prosecutor to present additional evidence within 5 days from notice, and the issue must be resolved by court within 30 days from the filing of the complaint of information. Letter B. By municipal trial court when required pursuant to the second paragraph of the section of this rule, the preliminary investigation of cases falling under the original jurisdiction of the Metropolitan Trial Court, municipal trial courts on cities, municipal trial court, or municipal circuit trial court may be conducted by either the judge or the prosecutor. When conducted by the prosecutor, the procedure for the issuance of a warrant of arrest by judge shall be governed by paragraph of his action. When the investigation is conducted by the judge himself, he shall follow the procedure provided in Section 3 of this rule. If his findings and recommendations are affirmed by the provincial or city prosecutor or by the ombudsman or his deputy, and the corresponding information is filed, he shall issue the warrant of arrest. However, without waiting of conclusions of the investigation, the judge may issue a warrant of arrest if he finds the examination in writing and under the oath complaint and the witnesses in the form of searching question and answer. The probable cause exists and that there is necessarily of placing the respondent under immediate custody in order not to frustrate the ends of justice. Letter E. When warrant of arrest not necessary. A warrant of arrest shall be not issued if the accused is already under detention pursuant to a warrant issued by municipal trial court in accordance with paragraph of this section, or the complaint or information was filed pursuant to section 7. This rule or is for an offense penalized by fine only. The court shall proceed in the exercise of its original jurisdiction.